Chapter 1, the introductory chapter, provides an overview of some topics that you'll need to keep in mind throughout the reading of the remaining chapters. Most of the topics are fairly straightforward. It's fairly easy reading. It does get tougher later, but enjoy this chapter, if for no other reason, just because it is a fairly simple chapter to read. Some things that people tend to get, I wouldn't say confused on, but it's just new language, new concepts for them. The difference between statutory and common law. Statutory law is law that originates by statute, and common law is law that is court-made law. Typically, common law topics would be things like agency, contracts, and torts, and statutory law would be laws that deal with crimes, sales. The Uniform Commercial Code is an example of statutory law. Commercial paper is statutory in nature. The laws dealing with checks and notes and drafts. So just know the difference between statutory and common law. Another topic that's worth paying attention to, stare decisis, essentially means to stand on decided cases. What courts will do is they will look at the current case before the court, and they will look back at prior decisions to see if there have been similar cases decided in the past. And typically, if the facts are similar, the issues are essentially the same, the court will look at those prior decisions and render a decision similar to what had been previously decided. Now, what this does, it doesn't guarantee that the court's going to decide a certain way, but it does provide a certain degree of consistency and some degree of certainty in the law, so that you know that when you've got a particular problem, if this has arisen and been decided before the courts previously, you have a pretty good idea of what the outcome would be should your situation end up in a courtroom. Now, even though stare decisis provides some degree of certainty and stability in the law, we all know that the law is constantly changing. The area of the law that I deal with, for example, employment law, there have been a number of changes to take place in recent years. The Supreme Court, just within the last year, rendered a decision against Abercrombie and Fitch on the topic of religious discrimination that got the attention of a lot of employers. The Americans with Disabilities Act that I deal with quite frequently has changed substantially over the last 5 to 10 years and is constantly being broadened by the courts. So the law changes. It's not stable. It doesn't always remain the same. And sometimes the laws change by different laws being enacted. That's probably the most obvious way that laws change. But sometimes laws change as a result of changes in society, changes in values. No better example could be seen than the decision within the last year pertaining to the rights that individuals have to marry regardless of gender. So the law does change, but you've got stare decisis that's at least to some extent providing some stability in the law. The difference between civil law and criminal law is worth paying attention to. Criminal law is where there has been a wrong against society. A civil wrong is a wrong against an individual. There is a difference in the standard of proof, or the burden of proof required, depending upon whether the issue is one that is civil or criminal. If it's criminal law, the prosecutor must prove that what is being alleged has occurred beyond a reasonable doubt. Now, that's a pretty heavy burden of proof, beyond a reasonable doubt. If you can't prove that what's being alleged is true beyond a reasonable doubt, then the defendant is found not guilty. If it's a case involving a civil matter, now this would be the kind of stuff that you sometimes watch on TV, the Judge Judy type of situation. It could involve a matter of contract law, tort law, something of that nature. The burden of proof is quite a bit less. In fact, if it is civil in nature, if you can envision the scales of justice with the scale starting out dead even, the plaintiff must prevail, and I'll show you by tipping my hand. The plaintiff is on this side. The plaintiff must tip the scales this much. Did you see that? We'll try it again. Here they are, dead even. Plaintiff wins that much. If you want to quantify it, plaintiff must prevail by, if you could quantify all of the evidence in terms of quality and quantity, the plaintiff must win by, let's say, 51 to 49. Just more likely than not, they can prove that what they allege is true, then the plaintiff wins. So you need to know the difference between the burdens of proof or the standards of proof, depending upon whether the matter is one of civil law or criminal law. And as I've noted previously, there are certain cases in chapters that you should read. I'm never going to require you to remember a case name, but it is helpful if you read some of the cases that I've put on the list that's posted on D2L. You've got one in this chapter that's worth paying attention to, and it's a case where an individual got fired for essentially not doing what his employer wanted him to do. The salesman was terminated for failing to go along with a sales program that the salesman thought was unethical, may well have been illegal. As I recall, there was an element that appeared to be fraudulent with respect to the advertising being done. The salesman simply just said, I don't want to go along with this. I don't want to be a part of it. The question there was, could the salesman recover for a wrongful discharge given those circumstances? And in that situation, the law of the state of Oregon, like that of Tennessee, follows employment at will. And essentially, employment at will says that an employer can terminate an individual in the absence of a contract to the contrary. So as long as I don't have a contract that says something else, an employer can fire an employee for any reason, no reason. The employer can make up a reason as long as the employee is not terminated for an illegal reason. That's the general gist of employment at will. Now, we've got a whole chapter coming up later, in fact, a couple of chapters that deal with various aspects of employment at will and the exceptions to employment at will. And we'll deal with that topic in much more detail later on, but it is worth reading the Lamson case just to kind of get a feel for how an employment issue would play out as I described. And in that case, the appellate court did hold for the employer and said that because of the doctrine of employment at will and under these circumstances, no exception to that doctrine would apply, the employer had the right to fire that person for any reason, as long as it's not an illegal reason. Now, throughout the chapters, starting with this issue, you will see questions involving legal matters that sometimes you'll look at it and you'll say, well, ethically, that's just not right. And because I deal with employment law, I can tell you that quite often individuals contact me. In fact, actually just within the last 2 days prior to my making this recording, I had somebody call me where the individual told me that they were fired inappropriately, and in their opinion it was just wrong, it was unfair, and I agree with the individual. I mean, after I learned what the facts were, I agree with them. It was extremely unfair, the circumstances under which they were fired. It, by anybody's definition, is just flat wrong to treat somebody like that. They were humiliated, and in fact, they were terminated, I think, in an unethical manner. But the manner in which they were terminated was not illegal. Again, employment at will says you can be fired for any reason as long as it's not an illegal reason, unless you have a contract to the contrary. Now, there are some more exceptions that we'll get to in more detail later in the semester, but for now, just be generally familiar with what employment at will says and how it plays out in the work environment. And we will be looking at issues involving the law and ethics in many of the chapters throughout the remainder of the semester.